all persons born or naturalized in the United States and subject to jurisdiction thereof are citizens of the United States and the state in which they reside.
No state shall enforce or make any law which shall abridge these privileges,
or immunities of citizens of the United States.
Nor shall any state deprive any person of life, liberty, or property without the due process of law,
Nor deny to any person within its jurisdiction
the equal protection of laws.
The 14th Amendment was passed by Congress on June 13, 1866, and ratified on July 9, 1868, placing it just after the Civil War.
The 14th Amendment was one of the amendments created after the Civil War. These were known as the Reconstruction Amendments. However, the 14th Amendment is regarded as the most important.
Amendments are what help shape our laws and values, and the 14th Amendment has been thought of as the heart of the Constitution because it guarantees us due process and equal protection of the law.
Equal protection of law protects us from states denying anyone in their jurisdiction.
This is known as the Equal Protection Clause. The state must treat each individual person to others in the same circumstances the same.
However, this calls into question,
What does equal protection mean to students?
students believe that we should all be provided the opportunity to learn and be aware of our educational rights.
Not every child was given the opportunity to learn. Not every girl had the same opportunity as men, and non-native English speakers were not given the proper opportunity to learn because the schools they were at did not provide them with the resources to learn English.
Brown versus Board of Education of Topeka, Briggs versus Elliott, Davis versus Board of Education of Prince Edward County, Balling versus Sharp, and Gebhardt versus Ethel. These 5 cases, heard by the United States Supreme Court, famously became Brown versus Board of Education.
In 1954 and 55, all of these cases addressed the same issue: institutional, statewide, legal segregation.
These cases concerned the issue of segregation of African American minors. They had been denied admittance to public schools based off of the laws that public education was segregated by race.
The minors argued that this violated their 14th Amendment right, specifically the Equal Protection Clause.
Plessy v. Ferguson had set the separate but equal concept.
At the time, this was a precedent concept that legalized facilities, such as schools, to have constitutional segregation if they were substantially equal.
Due to this, the people who had addressed this issue were denied.
This concept of separate but equal was anything but equal to those trying to get an education. The white kids were experiencing a better education and provided with a better learning environment,
while the African American kids went to schools that were neglected.
The Supreme Court unanimously ruled that the separate but equal concept was in fact not equal and violated the protections that were granted by the Equal Protection Clause in the 14th Amendment.
This previous case addressed the issue with students getting admitted into a school, but what was their quality of education once they got into this school? In Lau versus Nichols, Chinese American students were struggling to learn. The schools in San Francisco did not administer English lessons to enable the students to learn.
Students took schools to court saying that their civil rights from the Equal Protection Clause and the Civil Rights Act of 1964, Title VI, had been violated. Civil Rights Act Title VI prohibits discrimination on the basis of race, color, or national origin in any program or activity that receives federal funds and financial assistance.
And people with limited English proficiency must be able to participate in programs that receive federal funds, such as schools.
No one can be denied this civil right.
And to the question, does a school district violate the 14th Amendment or Civil Rights Act of 1964 when it teaches exclusively in English and fails to provide non-English speaking students with any supplemental English language classes? The court and we said yes. However, how about the girls and young women who during this time were being denied from educational institutions and athletics programs?
In 1972, Title IX of the Civil Rights Act was enacted by Congress and was signed as a federal civil rights law by Richard Nixon.
It was passed as one of the Education Amendments of 1972, and it prohibits public and private schools, as well as their athletic programs, from denying anyone based solely on their gender.
Because of Title IX, women are now able to participate in a wider variety of sports and are not denied an education.
But backing up to the reason why equal protection should mean something to students, here's why.
In many of the cases presented today, it was the students that brought the injustice to court, and it was them who made a difference.
It is important for us, the students, to know our constitutional rights because it lets us know where we started from and what we can do to make a difference.